Hello, I'm Catherine Mitchell. I'm here with my colleague Joanne Sefton, and I'd like to welcome you to the Mitchell Law Tea Break. This time our topic is settlement agreements, and I don't think we're giving anything away by telling you that we spend quite a big proportion of our time negotiating these on behalf of our clients, both employers and employees.
That's right, we did have a little debate about whether we should have this as a topic or whether we might risk giving away some of our secret strategies. Rest assured we're not going to give away too much about the approaches that we might take to individual cases, but there's plenty that we can talk about that's of general interest. So where should we start?
Well, it might be worth taking a step back before we get to the agreement itself to look at the negotiations leading up to the agreement. And there are a variety of circumstances where you might look to use a settlement agreement, but in most cases you'll be running a twin track approach. So there'll be an open process with the without prejudice closed discussions running alongside.
Yes, and one area where we sometimes see clients running into problems is where they get the two confused. Or more often people get so focused on the without prejudice side of things that they let the open process slip. If settlement negotiations work out, of course that's not a problem, but if not, then it can create a vulnerability if your procedure later comes in for scrutiny by a tribunal.
And it's worth mentioning that we tend to use the term without prejudice as a kind of catch-all description, and without prejudice actually has a technical legal meaning, essentially meaning that you cannot rely on those negotiations in subject court proceedings.
The idea being that parties can speak freely about the strengths and weaknesses of their position without that coming back to haunt them when they get to court.
Exactly, and those technical rules about when you can use without prejudice privilege that people often forget. So the communication has to be a genuine attempt to settle an existing dispute, and that can cause problems in employment cases when an employee might simply be offered a settlement agreement when, as far as they were concerned, there was no existing dispute. And there are other rarer instances where without prejudice won't apply, for example to cloak blackmail or fraud. So you do need to be aware that without prejudice is a legal construct with rules and not a set of magic words.
That's one reason why the concept of protected conversations was introduced by amendments to the Employment Rights Act in 2013. In practice, they actually seem to have added very little to the without prejudice rule, and that's probably mainly because the confidentiality only applies to unfair dismissal cases. It doesn't help where you have potential issues of discrimination, whistleblowing, etc.
And it's interesting that you use the word confidential there, and I think we all have a general notion that without prejudice discussions are confidential, but it doesn't strictly follow, does it?
No. That's one of those technicalities in this area that can sometimes trip people up.
Yes, and if you want an employee to keep an offer confidential, then you need to be stating that explicitly, and the same applies the other way around. So, and if an employee wants to ensure that colleagues don't get to hear about the exit package, then they should be doing the same.
So moving on from negotiations, let's say that you agree the basic terms of an exit package, and that's when we get to the settlement agreement itself.
Yeah, of course, and in many ways these are standard documents. They're also very long ones, so we're not going to talk about every detail, but what we are going to talk about is some of the key areas, and the hottest topic at the moment is the confidentiality clause that most settlement agreements contain.
Or NDA, as the press seems to be insisting that we have to call them.
Yeah, exactly, but our American cousins can keep their non-disclosure agreements, thank you. We'll stick to calling it confidentiality.
Okay, but will we stick with it? And that's the question, isn't it? There's a lot of noise being made about these clauses being quite invidious, particularly in the context of harassment scandals and the Me Too movement.
Yeah, but noise doesn't necessarily mean change. I think it's quite natural where a business is paying a large sum of money to get rid of a claim, for them to see confidentiality as part of the bargain. And often, although not always, employee clients are equally keen to keep the terms of their departure confidential as well.
I think we may be looking at evolution rather than revolution. We have the Solicitors Regulatory Authority guidance from March 2018 that reminded practitioners that non-disclosure clauses could be inappropriate in certain circumstances. And since then we've seen explicit carve-outs appear in most settlement agreements, confirming the underlying legal position that entering into an agreement doesn't prevent a party making a public interest disclosure, for example, or making certain types of disclosure to regulators or to the police.
Yeah, and what we've not seen much of yet is anyone trying to rely on these clauses to defend a disclosure where an employer is trying to claw back sums paid under a settlement agreement.
We did see the action against the Telegraph newspaper last year, where it was seeking to publish harassment claims made by women who had signed confidential settlement agreements in relation to conduct by Philip Green. The Court of Appeal granted an injunction against publication. It was held that there was a public interest in the allegations being reported, but that had to be balanced against the important role that confidentiality had to play in the settlement of disputes. And the balance wasn't in favour of publication, so said the Court of Appeal on the facts of that case.
Yeah, although ultimately Mr. Green dropped the case and it did come out, so that's a 1-1 draw in terms of how a contested case would work out. One that caught my eye was the recent city case of Natalie Abildgaard, who settled with IFM investors for $270,000 with no gagging clause this April. And in that case, the employer and employee issued a joint statement saying that the matter had been settled, but that she was not prevented from discussing it, and that a large portion of it would be going to a charity that she'd helped set up to help women who'd faced harassment at work.
Yes, that got wide press coverage, and I'm not sure that we would have seen that outcome from a similar case a few years ago. But it's less of a game changer when you realise that the litigation had already been started, and so there had been coverage of the open hearings that had appeared in the papers already.
And moving on from non-disclosure then, another area that we often have to tussle with is that of future employment, and the reference question comes up in just about every agreement.
Yes, although I think that's something that's evolving too. In the old days, of course, every employee wanted 2 sides of A4 about how great they were. And I think everyone is a bit more circumspect now, and references are often just the bare bones of dates of employment and job title, even when an employee has performed well. There's an exception to that, of course, in education. And there it's good practice to confirm that you have no reason to doubt that the individual is suitable for working with children.
Unless, of course, you've got a reason to doubt that, and entering into a settlement agreement doesn't absolve you from safeguarding obligations, including an obligation to make a DBS referral if that applies.
And that's something, of course, that we can advise on if you have any doubts about a specific case.
Yeah, and another interesting question I came across recently was whether a settlement agreement could ban an ex-employee from applying for future jobs with the same employer.
I can see the attraction for an employer in that, particularly a large one that perhaps does a lot of recruitment. If you've just managed to draw to a close a very difficult employment relationship, they'd want to keep it that way. I'm not sure, though, if it would be effective in protecting against a victimisation claim if the individual did make an application and subsequently bring a claim.
Yeah, and that's the potential problem, particularly when it's a grey area, as to the extent to which future claims can be compromised in a settlement agreement. So I suppose it might be worth considering in a very particular case, but not something that's appropriate to slap into every settlement agreement.
Well, as ever, lots more that we could say, but let's end on a lighter note. The oddest thing that we've ever been asked to include in a settlement agreement. I had an employee client once who worked in publishing who wanted to keep the books that were decorating her office, and we got them.
Well, that's a good one. And my favourite negotiation is the employee who called a without prejudice meeting with his employer out of the blue and announced that he required payment of a large sum in return for not disclosing highly sensitive information to a competitor.
Nice.
It was less negotiation, more blackmail. He didn't get very far.
Blackmail is not good, kids. And on that note, thank you very much for watching the Tea Break, and we look forward to seeing you again soon.